Hearing in the appeal Shanks against Unilever Plc and others.
May it please your ladyships and your lordships, I think the court's aware I appear with Miss Campbell for Professor Shanks, my learned friend Mr Alexander for Mr Hill for Unilever, the Unilever companies. As the court will appreciate, there are really two big points in the appeal. The threshold question of whether there was an outstanding benefit, and if that is, if it's held that there was, what a fair share of that outstanding benefit would be. There are, I'm going to deal with outstanding benefit first, if I may, and there are two essential facets to that. First is the identification of the correct undertaking. And then second, once one has correctly identified the undertaking, working out whether, in the light of its size and nature, not just size, but nature as well, the benefit is outstanding in all circumstances. And simply because these provisions are central to the appeal and have been subjected to some judicial comment as to their clarity, could I refer the court, please, just initially, to the provisions for a brief introduction. They are at E3035, found in Bundle 11A at tab 1. I know my Lord Kitchen is familiar with these provisions, at least from a previous encounter, but they do bear some careful scrutiny. The two types of observations that have been made, one more colourful than the other, about these provisions is that first, they lack clarity in the terms in which they're expressed. So terms such as outstanding and such as fair share are, on one view, vague, and one finds that at paragraph 7 of Mr. Justice Floyd's judgment in Kelly, as he then was. And the other facet relates to what might be called a mini disconnect between section 40 and section 41, specifically the anti-avoidance provision in section 41(2), which does not expressly in terms feed directly through into section 41. It is, we respectfully say, a minute technical drafting point. It wasn't the major source of difficulty when we went to the Court of Appeal the first time on the interlocutory point, but it is a fair point to identify with some clarity because it comes up in Lord Justice Patton's judgment in the Court of Appeal. So if the court just bear with me when I just show the court how it works, and I don't want to trespass on the court's time too much on this, but as the court's aware, section 40, compensation of employees for certain inventions, provides the ability for the controller or the patents court, if it's transferred to the patents court, to make the award where the patent is, this is 3 lines down in section 41, having regard, among other things, to the size and nature of the employer's undertaking of outstanding benefit to the employer. So that's the reference to benefit. And then, and the following 3 lines there, and that by reason of those facts, it's just that the employer should be awarded compensation to be paid by the employer. The court or the controller may award him such compensation of an amount to be determined under section 41. So it's clear from the use of the word benefit there and the reference down to section 41 that the benefit appears to be the same sum. And then we get at 41.1 over the page on E3036, at the foot of the page, section 41.1 provides that an award of compensation to an employee under section 41 or 2, and section 42 is where, in the different case, where the patent originally belongs to the employee, but has been transferred to the employer on terms which, when revisited, seem unfair to the employee. The award of compensation under 41(1) to an employee under section 41, for our purposes, in relation to a patent for an invention shall be such as will secure for the employee a fair share, having regard to all the circumstances, of the benefit which the employer has derived. So that must mean a reference back to 41. And if that is in any doubt, we can see at section 43.7 on E3039, section 43, subsection 7, in sections 40 and 41, and this section, benefit means benefit in money or money's worth. And against that background, which appears to intermesh section 40 and 41 together, we get section 41.2, which was the anti-avoidance provision which came before the Court of Appeal in the first trip to the Court of Appeal. And that's on E3037. And subsection 2 provides, for the purposes of subsection 1 above, the amount of any benefit derived or expected to be derived by an employer from the assignment, assignation, or grant of A, the property in or any right in or under a patent for the invention or an application for such patent, or the property or any right in the invention to a person connected with him, that's connected with the employer, shall be taken to be the amount which could reasonably be expected to be so derived by the employer if that person had not been connected with him. So, in the present case, the actual transfer from CRL to the assignee Unilever companies was an assignment for £100. And so that was the actual, I think it was a confirmatory assignment after that as well, but the actual assignment meant that Professor Shanks' employer, who was agreed to be CRL, the Central Resources Limited Company, Central Resources Limited, CRL, received only a couple of £100. And that's not an outstanding benefit, no one's contending it is. But Unilever, the Unilever companies, received a sum, a net sum, as found by the hearing officer, of £24.3 million, of which Professor Shanks received nothing then or since. And the initial position of Unilever was that CRL was the relevant undertaking. So that was their positive pleaded case, and they denied that Unilever Group was the relevant undertaking, which is where we've ended up. And that was on the footing that you couldn't attribute across from the assignee Unilever companies the actual benefit. And then what then happened, I'll take this reasonably shortly, was Unilever pleaded that at the time the assignment took place, they would only paid a few £1,000s. They didn't know how good it was going to be, and they weren't that keen on that sort of thing anyway. And therefore, that should be what an unconnected party would have paid. And that was essentially the hearing officer's approach. Professor Shanks, at some expense, went off and got expert evidence as to what deal would have been done by a third party, not knowing how good it would be. And that deal was 7% royalty, and see how we go. And then he got evidence about the market size, which was many billions, using that product. And that led to an exorbitantly large, on one view, theoretical sum, which would have resulted from doing the notional deal that Unilever was pleading, which then we embraced as an alternative case And that was ultimately effectively struck out, that alternative case, on concession in the Court of Appeal by Unilever that the real number to be attributed was the 24.3 million figure, as we now know it to be, then thought to be slightly less.
So the Court of Appeal's figure was a matter of concession?
The sum,
Yes.
we fine-tuned the amount of the sum,
Yes.
but what it represented was a matter of concession in the Court of Appeal.
Yes, because it does mean that the theoretically unconnected assignee is handing over the entirety of the profit, as it were.
It does,
Yes.
exactly.
Which may not be factually accurate, but it's a matter of concession.
Yeah, exactly.
Thank you.
Under Mr. Green, subsection 3 may be particularly illuminating for this argument you're presenting at the moment.
Subsection 3 of which?
Of section 41. Because it's dealing with a situation where the Crown or a research council, in its capacity as employer, assigns effectively its rights in an invention or patent for no consideration. And any benefit derived by the assignee is to be treated for the purposes of the foregoing provisions of this section as derived by the Crown. Now, if under section 40 the benefit was the nil consideration received by the Crown, there would be no benefit at all in money or money's worth. And so subsection 41.3 could never apply to a case of no consideration. Because that might be thought to imply that the benefit, that although as drafted, it bears, this deeming bears only to be for the purposes of section 41, it has to be read back into section 40 also.
My Lord, it does, and I think we all agree that that's the case. But it's right to point out that there is that technical drafting difficulty, which would be wrong for me not to acknowledge. But when, as your Lordship has done, and I was actually going to come to the Crown point more generally, but it's absolutely right that it does feed directly through. So when one looks at the two sections, 40 and 41 together, and one looks at 47.3, it's pretty much beyond doubt that it can't sensibly be construed any other way. Yeah. But there is that mini disconnect in a sense, but it must mean that. Yeah. And that was effectively what the decision of the First Court of Appeal held, was that the
difference, well, perhaps the point is that although there's, the deeming alters what we understand to be the benefit, it doesn't alter who we understand to be the employer.
Well, that's precisely the point. That's precisely the point. So we would respectfully say, I mean, I'm slightly jumping ahead, but your Lordship's there already ahead of me, but the essential point is that I think Lord Justice Patten was slightly, possibly, with respect, distracted by by perhaps losing sight of that point, if I might say so. Because if we look at page E163 in tab 6A of volume 1, before I dive into paragraph 33, can I just say that, parenthetically, one of the points that the Court of Appeal noted in its decision on the first the first appeal to the Court of Appeal was that deeming provisions should not be projected beyond their scope, beyond their necessary scope. And then what Lord Justice Patten says at paragraph 33 is he says, it seems to me that an assessment of what constitutes the undertaking based on the economic and business realities of the employer's organisation is the correct approach. If one takes a strictly legal approach, which is obviously one I'm going to commend to the court because we say we should follow the law, to the construction of the statute, it can be said that the employer is CRL and that CRL's undertaking in financial terms is limited to the nominal payments it receives on the assignment of the patent rights. Now, with respect, that is to confuse two completely different concepts in the Act. And that's really, we say, a pivotal error, respectfully, in the Court of Appeal's decision. Because it's wrong for two reasons. First, it conflates receipt of the sums in question with the nature of the undertaking itself. And secondly, it's wrong because 41.2 is an express statutory provision which caters precisely for an assignment at an undervalue between connected parties. And the terms in which 41.2 are expressed make it clear that it is the benefit derived or expected to be derived by an employer that is deemed to be the amount which could reasonably be expected to be so derived by the employer if that person not been connected. My ladies, my lords, the point we would respectfully make about that is there is a drafting election there by the draftsman. What you could say is where there's an assignment between connected parties within a group or otherwise connected under section 533 of ICTA, you just take the group as the relevant undertaking and then you don't need this deeming provision. So that is a clear and available alternative basis for structuring the drafting of this provision, and it's not the one that Parliament took. Parliament did not do that, but that is the approach that has in fact been taken by a sidewind by the hearing officer, we say with respect. I know my lord's poised to ask me a question. No. So that is the short point in relation to that. So we acknowledge that there is, I think it's something called open textured phrases such as outstanding and fair share in these provisions. But in relation to the suggestion that they are very ill drafted, we respectfully say that's not, on analysis, not quite right, because when you construe them as a whole in the usual way, you can see that there's the read-through, as my lord pointed out, in relation to Crown, the word benefit, and benefit in money's worth. So we respectfully say that any infelicity in that respect is not such as to justify either not taking a strictly legal approach in that sense, or just letting go of the reins completely of orthodox statutory construction and doing what you feel reflects the reality on the ground in some general way. Parenthetically, I'll come to this point later, we also say if you do look at the reality on the ground, it certainly doesn't lead to the conclusion that the hearing officer reached for some fairly obvious reasons, which I'll develop in a moment, if I may.
Well, you can't take a broad brush approach to legal rights.
Well, precisely.
Clearly, Section 39 confers a right of property, and Section 40 is dealing with rights to payment.
Precisely.
So there has to be a legal entity which
yes.
is the subject of these rights and obligations, and on the employer's side, it's the employer.
My lord, it makes it clear, and we respectfully say the undertaking can't mean anything beyond the business and assets of CRL. If it could, you'd have to be very specific about which part of the business you had in mind, but it certainly can't mean the entirety of Unilever's global undifferentiated operations all around the world. In 3 lines in the decision. And it may be convenient, my ladies and my lords, for me just to make this short point as well, which is that the justification, the supposed justification for doing this, is that it respects reality and it's not a prisoner to the particular structures which corporate structures which Unilever has put in place. But that's absolutely not the case. What this masks that this result is precisely because of the way Unilever has structured its business. As I can explain, what happened was, on the 1st of June 1978, which coincidentally was the date these provisions came into force, Unilever put all of its researchers from all of the different Unilever companies and divisions within those companies into one company, which is CRL. Now, I should say in fairness, Mr. Samuels, when he was cross-examined about this for Unilever, said that Unilever wasn't trying to avoid that statute. He said Unilever was trying to avoid a different proposal in the Bullock report to have employees on boards, so they'd bury them 2 layers down, in his words. So Unilever's position was they weren't trying to avoid that particular statute, they're trying to avoid another one. But it doesn't matter what the intention is. The question is, what is the effect if a large group chooses to put all of its researchers into a company that has no income of its own, usually, other than what it receives from other group companies, and use that as a basis for actually distorting the reality that would otherwise exist. And I invite the court to think, Unilever's got all sorts of completely disparate areas of endeavour. So let's take 2 examples. I don't know whether these are actually their examples or not, but let's take antiperspirant and baby food. And if there was a company producing, a separate company, if we assume, producing baby food, and it had 3 researchers working on fascinating formulations of baby food, and one of them came up with a brilliant idea, the employer's undertaking would obviously be Baby Food Limited. And there was no sensible suggestion that it was anything else. And if at the same time, someone in Antiperspirant Limited came up with the most genius idea for an antiperspirant, and there were 3 researchers there, and that was an absolutely extraordinary success, there'd be no question that the antiperspirant company would be the employer's undertaking for that purpose. But the irony of this is that by Unilever putting all of the relevant researchers into one pot in CRL on the date when the Act came into effect, it's then able to say, well, the undifferentiated pool of researchers in CRL were all doing work which would inure to the whole group. But I mean, what that masks is the fact that individually they were separately organised into various divisions and sections and clearly identified as doing, with very narrow and strictly enforced remits often, doing specific research for very specific aspects of Unilever's endeavour in its particular companies. And so, my ladies, my lords, we respectfully say that simply saying, well, we can't see beyond the fact that all of the researchers are researching everything for the whole of Unilever, so we're going to say it's the whole of Unilever, falls into the very trap of taking an artificially big entity, I mean an extraordinarily big entity, instead of one that's actually functionally relevant to what happened. And we respectfully say, as my lord's already observed, that where a writing question is such as this, there is a need for some rational and functional basis for identifying the relevant undertaking. We respectfully say that certainty would point towards CRL as the relevant undertaking. Now, in fact, Professor Shanks worked in a specific division of it, and there were a number of arguments deployed about the appropriateness of subdivisions, because in all the previous cases, the courts have accepted that it could be a subdivision of the employer. So in Kelly, for example, it was a division of Amersham, not the whole of Amersham. GEC Avionics was also accepted, and so forth. It's been a subdivision. But this approach is unprecedented, albeit I accept in a field of the law that's not very well developed. So we respectfully say, A, it's wrong on the statute. B, the Court of Appeal got it wrong for 2 reasons in paragraph 33. And C, it falls into the very trap that it's said to avoid. The avoidance of that trap being supposed to be the justification for effectively departing from the statutory wording. And we say, A, you shouldn't, and B, you certainly shouldn't like that.
The way you put it may not be quite precise. You said that CRL was the undertaking. Strictly, if we're applying the statute, CRL is the employer.
It is, my lord.
The first reference to employer is an invention belonging to the employer.
My lord, yes.
So the owner of the invention is CRL.
Indeed.
The next reference is the employer's undertaking. And then benefit to the employer, and finally compensation to be paid by the employer, and the payment obligation would be CRL's obligation.
My lord, yes.
So what one's asking oneself in relation to undertaking is what was CRL's undertaking?
Well, it must be that, precisely. I'm sorry I slightly took a bit more soft-edged in describing that, but that's absolutely right, because it's describing CRL's undertaking. And there's a slight giveaway, because the hearing officer himself, at the end of his, in para 223, says, well, having regard to Unilever's business. As if it's the business of Unilever. Well, if the undertaking means the business, it's the business of CRL.
And if that's right, then you're not concerned with the manufacture of toothpaste or ice cream or...
Precisely. My lords, actually, the evidence of... it was a point Mr. Emmanuel, the extremely measured expert, licensing expert who the hearing officer preferred, a point he made in his evidence, which is that actually, if you were to look at the group as a whole, the fact that the group had a couple of 100,000 employees worldwide and somewhere between 70 and 90,000 in the UK at the time merely accentuates the significance of the fact that Unilever as an entire group couldn't identify any individual patent which had from which it had derived a benefit of that order of magnitude. It's much more striking across tens of thousands of people over a period of 30 years than it would be in a small startup with 5 people. And you say, well, actually, Mary's working on this, and that should come through in the next 3 years. John's had a lucky strike, his came through earlier, but we're all going to be brilliant. But if you've got a 30-year landscape of evidence and the respondents decide to adduce evidence in a certain way which doesn't come up to proof, to suggest some value of patents, even if you were to look at the group as a whole, or to look at the group as a whole as an indicator of CRL's inventiveness, if you assume that every single invention and patent comes out of CRL, the fact that Unilever could identify no other patents, family of patents, from which they got anything like that order of magnitude of benefit is more striking and more outstanding, not less. So as the court will appreciate, this is a pretty exceptional case in the sense that 24.3 million was achieved with no material risk to the respondents, no invention cost, because Professor Shanks invented it within about 6 months of joining, no marketing, no approaching of licensees. There was one who they approached about something else and mentioned this in the conversation. But all the licensees beat a path to Unilever's door. And it generated an extraordinarily high rate of return, which troubled even Mr. Justice Arnold. The learned friend's written case suggests that the hearing officer failed to take into account the costs of the invention, and that's not fair to the hearing officer. The hearing officer considered that point carefully. I can show the court the references, and it's clear that he found that there really were no costs of the invention, because although my learned friend asserts now that this fell well within Professor Shanks's duties, the completely uncontroversial premise of the entire proceedings below the hearing officer was that Professor Shanks had done all his contracted duties in full. There were lots of examples. So it was a rather fantastic invention for detecting leaks in salmon cans, for example, where there was poisoned food going out because of the leaks. And Professor Shanks came up with an absolutely brilliant idea, which was identifying these leaks using a revolving system with a magnetic way of identifying the leaks. So Constanta Teabag's machine, all sorts of things that he did. So there was absolutely no suggestion that he had gone completely off-piste and not done what he was contracted to do. And quite to the contrary, the hearing officer accepted his account of how the invention had come to be made, which says that he realised that there had been a possibility for improving glucose testing, and had begun to think how his previous experience at RSRE in LCD crystals might be able to help provide something that would be precisely accurate and able to be manufactured in very vast numbers extremely cheaply, because it would have to be so if it was to be disposable. And the hearing officer accepted his account of that and how he made the invention at home using his daughter's toy microscope kit. He read up on all the related areas of science, necessary enzymes, studied ferrocene mediators to see how you could get something to bind to the blood within the capillary so that the electrical charge would precisely measure the amount of sugar in the blood. And he did that all on top of his contracted duties. So it's an extraordinary case. And the short point is, if Professor Shanks doesn't win, there will never be any other case brought against a large company ever, and there may be no other case brought again at all.
Are you going to take us in due course to the paragraphs in the hearing officer's judgment?
My Lord, absolutely. I'm just going to
these
go
findings were
in
made.
a moment.
Yeah, very good. Thank you.
So that's the background by way of overview. It may be convenient to take the court to that now. If I can invite the court to look at it's tab 19 in volume 2, and if we can begin perhaps where the hearing officer ends at E419. The two key paragraphs on E419, which is internal page 46, are paragraphs 222 and 223. And this is the hearing officer's conclusions on whether the benefit is outstanding. And just before going into these two paragraphs themselves, can I just show the court the context in which this is analysed? So he asks the question, was the benefit outstanding, on page 415. That's his major heading. And the way he approaches it is to look at the statutory provisions briefly at 198 to 200. And he notes the point, which is that Mr. Justice Floyd analysed in Kelly why there was a difference in requiring an outstanding benefit where the invention originally belonged to the company, the employer. And he identified that the requirement of outstanding benefit is to distinguish between the situation where, on a review of an assignment from an employee where it was originally owned by the employee, the court thinks it was a bit unfair to the employee, from a situation where, when owned by the employer, the disparity of benefit between the two is extreme. And the hearing officer at 200 says, in simple numerical terms, because we submitted that the difference between, in fact, Professor Shanks didn't get the £100 assignment fee. That was from CRL, received by CRL. He actually got, I think, $1 deemed received twice. But we respectfully submitted that the difference between 24.3 million and nothing was an extreme disparity in any context. And the hearing officer says, in simple numerical terms, this is plainly so, but I do not read Mr. Justice Floyd as meaning to create an alternative test to outstanding. There's a need to consider the disparity in the overall context of the size and nature of the employer's undertaking. Now, pausing there, we respectfully agree that he's not creating an alternative test per se, and the size and nature of the employer's undertaking will always be relevant because that's what the section says. But it is helpful when seeking to construe statutory provisions to have regard to facets of their statutory purpose which have been identified either in the legislation itself or by, for the hearing officer's purposes, a binding decision of a higher court. Then the structure is that he takes the benefit in the light of Unilever's profits and turnover, just above 201, and the point being made by Unilever was one of their two big points in the case. The two big points were, one, this number is not significant to Unilever. £24.3 million is not significant to Unilever, although fighting tooth and nail against giving away a small proportion of it. So one was it's not significant to Unilever, and two is this is an entirely run-of-the-mill benefit from a patent. Those are their 2 points. And they lost on both of them. And we can see that they lost on the first one at 202. This was Mr. Samuel's evidence. 18 million additional write-down had not required a restatement of the accounts, and that 23 million is not even material at management group level. In my view, he somewhat overstated his case and was challenged in cross-examination, being shown evidence of top-level Unilever management being concerned about losses of £15 million in another case, on another project. He admitted being surprised by it. He was also surprised by discussions of reducing research budgets by £500,000, but that didn't find expression in the hearing officer's decision, didn't need to. I have no difficulty finding that the size of benefit being considered in this case is small compared to Unilever's overall profits. But that does not mean that Mr. Alexander's argument immediately carries the day. So we'll pause there. He goes a little firmer, we see, if we just go forward to paragraph 222 at 419, just see how that translates into the conclusion. Considering the totality of the evidence, I was left with a clear impression benefit provided by the Shanks patents was a substantial and significant one. In money terms, the sort of sum Unilever would, on the evidence, worry about. CF Project Hyacinth, plainly a reference back to the paragraph we just looked at. And then he says, furthermore, in comparison to the benefit from other patents to Unilever, from the evidence before me, it does, in Mr. Emmanuel's words, stand out. Unilever, in its original counterstatement, pleaded another example of out-licensing in relation to nappies. I think £1.3 million that it got for that, but then it didn't really produce any evidence on that before the hearing officer. But there was nothing of any similar order of magnitude that Unilever could point to, even when the hearing officer pressed my learned friend in closing submissions, very specifically on that point. And what Unilever says in relation to it standing out is, well, we're not an out-licensing business, and that's why our patent department wasn't really very experienced in doing that, and why we don't have very many comparators of other patents. And then Unilever goes on to say, and it's totally unfair to a company with a turnover of tens of billions to have to do a Kelly-like exercise in order to prove a benefit from another patent, by way of example. To which we rhetorically say, well, Unilever chose not to do that before the hearing officer, and why is it fair to require an employee, such as Dr. Kelly and Dr. Chu, to do a Kelly-like exercise to establish their right to compensation, but say that a company with a turnover of many billions of pounds, for them it's not proportionate that they should have to adduce similar evidence. We respectfully say the evidence before the hearing officer was as it was, and it was a pretty good indicator that this was an absolutely astonishing return, both because the rate was 100 times the investment in the cost of the invention and the patenting, and secondly, because there was no risk, and thirdly, because all the licensees had come to Unilever and approached Unilever for a license. They hadn't had to even do a marketing campaign. They hadn't done any of the things on Unilever's own expert's website, front page, saying what you do when you want to out-license, apart from the final step, which was the actual licensing. So the hearing officer finds at 222 that the benefit does stand out compared with other patents to Unilever. But he finds it's not outstanding. So it's one of those benefits that stands out but is not outstanding. And the reason he finds that is those last 6 lines of para 222. Really, the first 3 of those. But Unilever makes profits at an order of magnitude greater on other inventions, albeit primarily by manufacture, and at a much lower rate of return than was provided by the Shanks patents. Now, we respectfully say that is not a satisfactory basis for displacing the conclusion that he otherwise would have reached. Particularly when he carefully goes through different perspectives from which he is going to judge whether or not it's outstanding, and they all sing with one voice, apart from the fact that the entire undifferentiated Unilever group profits worldwide are much larger. And my learned friend takes point in his written case where he says, we previously said all factors spoke with one voice, and we now say there was only one factor that decided the case. Well, we still say that. All the factors, apart from that, did speak with one voice, and it was actually more of a unifactorial decision at the end, where this unusual approach to the undertaking, and then the further step of a completely undifferentiated and vague statement about global profits, which we say is not appropriate to assessing payment for a property right, is said to be an answer to the conclusion that it's pretty obvious he otherwise would have reached. The intermediate steps and perspectives between paragraph 201 on E415 and the conclusion are found at E417, which is the benefit in relation to patents in general. And Mr. Emmanuel's evidence, Mr. Emmanuel was the licensing expert preferred. His evidence is recited at the bottom of 210, last 4 lines. Mr. Emmanuel commentated, in the context of these values, Professor Shanks' patent was very, very unusual. And then 211, Mr. Emmanuel considered that experienced licensing executives would regard the benefit of the Shanks patents as outstanding, which was the licensing perspective. And he was the paragraphs, I think, 7 and 12 of the decision where the hearing officer makes clear that his expertise and experience shone through. The present case went beyond that, particularly given that it was a bare patent outside of the pharmaceutical field, and Mr. Emmanuel considered this to be extraordinary. And we haven't been able to find evidence of a bare patent assigned for that sort of sum. With no know-how, no FDA approval, none of the usual other things that one might expect to find sold along with patents. And then 212, I do not believe these comparisons are of much assistance. The question of outstanding benefit must be considered in the context of an employer's undertaking. A patent might very well provide outstanding benefit in that context, even if it did not stand out amongst patents generally. Conversely, I find it hard to see how a benefit of £50,000 could be considered an outstanding benefit in the context of Unilever's overall budget, even if generally patents are licensed for much less. Now, just pausing there, this wasn't a benefit of £50,000 being said to be an outstanding benefit in the context of Unilever's overall budget. This was a benefit of £24.3 million, and we respectfully say that the hearing officer was wrong to disregard the significance of the patent in terms of patents generally. If a patent, on any view, wherever you are, is totally outstanding, it's wrong to disregard it, to disregard that, because the section says, having regard, amongst other things, to the size and nature. It doesn't say having regard only to the size and nature of Unilever. And it's obviously also a prisoner to taking the entire Unilever group as the relevant comparator. He then looks at the benefit in the context of Unilever's licensing activities, and he briefly deals with that and says Unilever's not a licensing out company, rather a company on focused on products. He then says it does not follow at 215 on page E418. It does not follow, however, that the benefit in money or money's worth is outstanding. On this, I agree with the point Mr. Alexander put forward, which was that how the benefit was made is not relevant to whether it's outstanding. What matters is whether the benefit in money or money's worth is outstanding in the context of the undertaking as a whole. Just because a company does not usually make money in a certain way does not mean that any sum, no matter how small relative to the size of the company's usual business, is of outstanding benefit for it. Now, in a sense, that only goes so far, and there's nothing literally wrong with that. All we would quarrel with is we say it does matter how the benefit is made. And he's wrong in line 3. Because what's outstanding, a benefit that's outstanding from a Kelly situation where Dr. Kelly was paid £100,000 a year and Dr. Chu was paid £80,000, I think, to work specifically on research towards MyView. What's outstanding when the company puts a lot of its research behind something? And what's outstanding when an employee, in his own time, comes up with a brilliant device outside anything that Unilever actually does in its main business, from which Unilever gets £24.3 million, we respectfully say it is relevant how the benefit is derived in that sense. And elsewhere, the hearing officer says it doesn't matter whether it's 1,000 people or one who make the invention. And again, we say that's wrong. We say the benefit that you might get from the endeavours of 1,000 people, particularly if they were tasked specifically to work on a particular project, might not be regarded as outstanding. That cannot be the right approach. So we say, even within his analysis, there are strikingly surprising aspects of the hearing officer's reasoning. He deals with no significant risk to Unilever under fair share at E421, para 235. The defendant's contribution here, this is to making, developing and working of the invention, was mainly, and other advice and facilities. The defendant's contribution here was mainly significant in its work to obtain licenses from the Shanks patent. Unilever made a very small effort, by its standard in money terms, to commercialise the invention. The licensing efforts I have found to be serious, but not exceptional in terms of commitment made. There was no significant risk to the defendants as a result of their efforts. So essentially, what Unilever did was the licensing in relation to the benefit. Nothing towards the invention. At paragraph 220 on E419, he says there's one noticeable difference between the benefit in cases such as Viennetta, which is the ice cream, and the present case, the amount spent by Unilever to get the benefit. Profits of hundreds of millions on revenues of billions necessarily implies expenditure in the hundreds of millions. Now, there's an arithmetic mistake there, which I can just point out in a moment, but the broad point is he's saying that it's a proportion. There must be a large amount of expenditure. In fact, arithmetically, profits of hundreds of millions on revenues of billions necessarily implies expenditure in the billions, in fact. It is not possible to go below 1 billion. So that's mathematically wrong by one order of magnitude, but leave that aside. He's pointing out the fact that the amount spent by Unilever to get benefits in other cases involves them putting at risk hundreds of millions at least, if not billions, of working capital to produce and manufacture products, which is a completely different case. He says, under my own approach, which is to look at the benefit from the patent, even most of those costs can be ignored, giving a very high rate of return. He said, I agree with the suggestion from the claimant that this is relevant in his favour. So he agrees that the rate of return is in principle relevant, but then he discounts it in a way which we say is flawed and impermissible. Because he says, bear in mind, under this approach, all successful patents will have a high rate of return. And a small sum generated by a still smaller sum is still a small sum. Well, that's plainly and obviously wrong, we say. You might have an enormous cost to the employer of making an invention. There's absolutely no basis for saying that at all, unless you define a successful patent as one which has an astonishingly high rate of return. But here, the high rate of return was because there was no invention cost to Unilever. And that's very, very rare. So the hearing officer, in our respectful submission, is obviously wrong about that premise, by which he then disregards, or at least mutes, the importance of the very high rate of return. So he respectfully says he's wrong about that. And then 221, Mr. Emanuel gave evidence considering the average revenue generated per person in Unilever. He considered someone ultimately generating more than 23 million for Unilever in the first 6 months or year they arrived to be a little outstanding from the general run of Unilever people. Unilever takes the point, well, it was received over a number of years. But that's always the case with patents. It's the endeavour that took place in that first 6 months and the ingenuity. One doesn't ask, how long did Sir Isaac Newton take to watch the apple fall from the tree? To identify the effort or skill put into identifying gravity, what you look at is the invention, we respectfully say, how it's made, and then the benefit derived from the patent upon it in a rational way, and without artificially excluding obviously relevant factors. So, Unilever, in their case, just in relation to the high rate of return, they say at, I can give you the court reference, don't need to take you to it, it's at E82, paragraph 114b, they say that the hearing officer did not take account of costs of the invention when there were none, but took a cost of patent costs at 250,000. Well, the point is he did take account of what the costs of the invention were, and there weren't any costs. That's what he based his decision on. And he recited the submission to that effect, our case, that there weren't any costs of the invention at paragraph 180 at E411. In relation to taking an arbitrarily large employer's undertaking, which point goes back to the submissions earlier about how the section works, the hearing officer dealt at paragraph 195 at E414 about halfway down the word obtained in the left-hand margin. It then says, it would be equally wrong to enable a claimant to pick an arbitrarily small subsection of the group, and the tiered proposals by the claimant somewhat smack of this, and by attributing the benefit obtained by the entire group to that subsection, magnify its apparent significance. Those were subsections of CRL. And he then says, however, I do not believe it's a complete answer because I conceive of situations where an undertaking may be a subset of the whole, as in Kelly. Well, that was also the case in British Steel, to which he referred above at 193. And the key point in 195 is that he says it's wrong to take an arbitrarily small subsection of the group. We respectfully say it's also wrong to take an arbitrarily large entirety of the global undifferentiated profits of Unilever and use that as a way to deny Professor Shanks the compensation that he would otherwise have received. One aspect of the case was that this was essentially regarded as an orphan technology to some extent, because it had no natural home within Unilever.
I'm sorry, before we leave this,
Yes.
paragraph 196 seems to be really central to his reasoning. Because he doesn't accept...
My lord, that's what I'm coming on to.
Oh, you're going to come on to it, fine.
Well, I can deal with it. It doesn't matter which way I do it.
I'll be patient in that
The
case.
point is how it fits in. And your lordship's absolutely right. 196 says, in the event on the facts of this case, I find that the reality of the situation is that described by the defendants. And this goes back to the point of principle I mentioned at the very beginning of my opening. Regardless of how the various companies in the Unilever group have been structured, researchers at Colworth employed by CRL were doing work which was going to be exploited by the group as a whole. Well, that is the finding at a very high level of generality, upon which the very mistake that is said to be avoided by taking the Unilever group as a whole is actually made, because Unilever put all the different researchers from all the different companies and all the different divisions of each of those companies into one pot. He then says, indeed, it's notable that the whole benefit from the Shanks patents was generated by licensing activity operated out of the central Unilever companies. Having regard to the size and nature of the employer's undertaking, therefore requires me to have regard to whether the benefit from the patents is outstanding in the context of the Unilever group as a whole. Well, my Lord, we respectfully say that is wrong, because the only relevance of it being out of the... All that happened was that Unilever's patents department, which lacked a skilled, dedicated licensing team, as the hearing officer expressly found, did their best. Poor old Mr. Tate was under huge time pressure and didn't have time enough to devote to getting out the value, as he candidly admitted in correspondence. But they did their best, centrally, we admit, to license the patents. But I mean, there's no functional relationship with the manufacture of goods in Nigeria or manufacture of antiperspirants in Italy or anything else. There's no functional significance of that at all. And he's quite wrong to feel driven, as he appears to there, by the fact that because the assignment is made to the group companies, he's got to look at the group. And that's what he does appear to be saying. And he's wrong about it, we respectfully say. So those last 4 lines, the last 6 lines, the right-hand side, indeed it's notable that the whole benefit from the Shanks patents was generated by licensing activity operated out of central Unilever companies. Well, it's only because they were the ones to whom it was assigned. Having regard to the size and nature of the employer's undertaking, therefore requires me to have regard to whether the benefit from the patents is outstanding in the context of the Unilever group as a whole. Well, it doesn't. So he was wrong to feel compelled to do that. And that's a clear error, which he declares for himself there. But it's also wrong for the reason that I was just beginning to introduce before my Lord directed me to 196, which is that this wasn't a technology which fitted into any of Unilever's divisions or other companies. It was regarded as, referred to in Unilever's original counterstatement, I think, as an orphan technology. And the point about that is that this shows that the taking of the Unilever group as a whole is doubly irrational. Because had it been directly relevant to, for example, Baby Food Limited, but invented at CRL, there could have been an argument, if one is to go outside CRL, which is not our primary position, that you imagine the undertaking to include the Baby Food Limited turnover and so forth as somehow relevant to considering CRL's undertaking. But because it didn't fit anywhere, because there was no intermediate home for this hypothetical departure from the statute, we got the whole lot, which is even more irrational, we respectfully say. It was a sort of backstop position, unable to find a natural home for this technology. We're going to say, oh, well, it's everything then. And if that is the approach, then no one's going to win against a large company that structures itself in this way, or possibly ever. My ladies, my lords, I mentioned in passing the original counterstatement and the reference to the other the patent at 1.3 million. It was actually 1.5 million. The E reference, in cases of interest, is E2729. It's in bundle 9, tab 62, tab 17. That was the original positive case. And we respectfully do say that when one then comes back to the fact that there was no similar benefit from any patent, even by manufacture, identified on the evidence actually before the hearing officer, there was really scant basis even for the generalised conclusion that he came to reach in paragraphs 222 and 223. Because he hadn't been shown any correlation between any particular invention and the actual numerical benefit at all. And indeed, in cross-examination, there was a challenge, but you might have a patent on doing something a particular way. Someone engineers around the patent and comes up with something that consumers prefer. So it's actually harming you. You don't know unless you analyse it. And the point about that was that the force of Unilever's challenge was, A, it's not significant sum, which I've already dealt with, on which they lost, as we've seen at 222, and B, it's entirely run-of-the-mill. And the court will find that phrase in both the opening and closing skeletons that Unilever had before the IPO. I can just give the page reference, I don't need to take the court to them, but paragraph 6 at E577, which is bundle 3, tab 24, page 3. Para 136, which is E610, which is bundle 3, tab 24, page 36. And then in the closing skeleton at paragraphs 16, which is E624, at volume 3, tab 25, page 6. Paragraph 236, which is E683, volume 3, tab 25, page 65. And paragraph 292, E694, which is volume 3, tab 25, page 76. So they ran the run-of-the-mill case fairly and squarely and lost on it. And it wasn't just running the run-of-the-mill case on out-licensing. It was, this is what the opening skeleton at paragraph 6 said, they're run-of-the-mill for an expected return on inventions made by a team of senior scientists in a large company. And they failed on that case. And at 136, if this were held to be outstanding, a large number of run-of-the-mill patents, which were only valuable because they happened to have been invented in or for large volume businesses, would qualify as outstanding. But that's just not the case. That doesn't even relate to this invention. Because it wasn't because Unilever manufactured millions and millions of widgets worldwide that they received this benefit. It wasn't a function of the scale of Unilever's manufacturing operations that they received the benefit they did. It was a bare license on patents. There was not only did they fail on it, but it was also, we respectfully say, not a good argument in any event. Could I take the court now, please, to paragraph 103, which I foreshadowed earlier in the hearing officer's decision. I'm sorry. It's paragraph 221 in the hearing officer's decision. I'm so sorry. Which we find on page E419. And it's the latter part of that paragraph. We've already looked at it briefly. The 4 lines down in the middle, that argument seems to me to fall into the trap of considering the inventor's skill or effort. Whether or not the benefit is outstanding does not depend on whether that benefit was created by the work of one person or 1,000, although the distinction would assuredly matter when considering a question of fair share. But we respectfully say that that's wrong in 2 respects. First, it is absolutely right that Mr. Justice Floyd in Kelly said that when he was considering the compensatory nature of the award, which was asserted by GE, they said this is compensation for some sort of loss because the employee inventor's not been fully compensated by his salary. And Mr. Justice Floyd, as he then was, said, well, no, that's not right. It's not compensation for loss, and there's no threshold requiring him to have used skill and effort beyond that for which he's been paid. But we respectfully say that saying there's no threshold for that is not the same as saying it's completely irrelevant. And the court's already got my submissions on Professor Shanks making it home in addition to all his other duties, and they won't prove by repetition. I mean, it's obviously wrong to leave out a feature that is particularly striking as a matter of common sense on what we say is essentially a false premise. And we also say that, for the reasons I've already canvassed, it's quite wrong to say whether or not a benefit's created by the work of one person or 1,000 is irrelevant. Let's say one person comes up with a benefit of £1 million in a company, entirely on his own, in 6 months. Is it identical for the purposes of Section 40 if 1,000 people work on it, presumably all being paid at the same time, and derive a benefit of £1 million? I mean, we respectfully say that's absurd and can't possibly be right. But that is what the hearing officer had in mind in reaching the view that he did. So, my lords, my ladies and my lords, the learned friend's written case refers expressly to the relevant paragraph, to paragraphs 33 and 34 in the Court of Appeal. Can I just show the court that? It's at E73. It's volume 1, tab C.
What was the E reference, please?
I'm so sorry, my lady. It's
My fault.
E73.
Thank you.
If we look at paragraph 84, this is my learned friend's reliance on the very paragraphs that I took the court to earlier from the judgment of Justice Patton in the Court of Appeal. And we see there, 3 lines down, if one takes a strictly legal approach to the construction of the statute, it can be said that the employer's CRL and the CRL's undertaking in financial terms is limited to the nominal payments it receives. The court's already got my submissions on why that's wrong. And then paragraph 85, my learned friend pins his colours to the mast on this and says it's submitted that there's no rational answer to that analysis. I just invite the court to note that I hope I have made clear what our answer is, and that the submission that there is no rational answer is, we respectfully say, completely misplaced in that respect. Just pulling the camera back to a slightly higher level of abstraction, the point about the Crown, which my Lord mentioned in the context of statutory construction, found in section 41.3, is taken up by my learned friend at page E79 in his written case, at paragraph 108. And he says the contention, the hearing officer was wrong not to have regard to the section 41.3, which I think the subsection my Lord referred to, is obviously wrong. Where the Crown is the employer, the relevant undertaking still has to be considered and its size and nature taken into consideration. There's no quarrel, just to avoid any unnecessary dispute. Of course, the relevant undertaking has to be identified, and its size, and particularly its nature, amongst other things, have to be considered, because that's what the section says. There's no quarrel with that. And then it says, although it depends on the precise facts, it seems unlikely this would ever require consideration of the entirety of the UK government, given the many discrete parts and functions that it has. So my learned friend there, to escape the problem on the Crown, is urging upon the court precisely the analysis of some functional relationship, which is my second-tier submission. And he then says, for the most part, departments or agencies would have to be considered. In any case, there's no reason to believe a suitably substantial benefit would not be generated in exceptional cases. And then he says, depending on the circumstances, it might have to be an order or orders of magnitude larger than the benefit made from the patents. Well, really? Let's take the example of a GP working in the NHS, and she comes up with a brilliant invention, which is patented, and it's actually used both by the NHS to save tens of millions of pounds, and also brings in £10 million of out-licensing revenue to American companies. Is it really the case that she can't get an award because the NHS is so huge? We respectfully say no. We respectfully say that's not right. Just because the employer is absolutely gigantic doesn't exempt the employer from these provisions.
It might be thought that the implication of the hearing officer's reasoning in paragraph 196 is that it wouldn't be enough to consider the Crown.
I'm sorry,
because it wouldn't be enough to consider the Crown, because if you're in a section 41.3 situation, I mean, he's envisaging a section 41.2 situation, but say it's the Crown.
Indeed.
And the Crown doesn't, and you have a situation where people doing research employed by the Crown are not going to have their inventions commercially exploited by the Crown itself, but they're going to be exploited by another body to which the Crown assigns the rights. Then on the reasoning in 196, you treat that latter body as being its undertaking as being relevant along with the actual employer's undertaking.
Indeed. I mean, it's almost unbounded, potentially. Maybe overstating it slightly, but it is capable of being extremely expansive. So we have to take the Crown and the agency and add them all together. So it's not just the problem of the Crown. It's even bigger. So we respectfully say it's pretty obvious that cannot possibly be what Parliament intended, because the Crown is going to dwarf Unilever many times over. And my Lord, that's why we respectfully say that actually there comes a point where the size of a benefit can be said to be outstanding, almost regardless of the size of the employer's undertaking, particularly where it is derived with no cost and no risk. The inventions are made with no cost and the benefits derived with no risk. And it stands out and is an entirely new revenue stream for the employer, in addition to the employee's duties. And that's not to say that size and undertaking are irrelevant. It's simply to say size and nature of the undertaking are irrelevant. It's simply to say, it's rather like when you say to somebody, can you only let children of certain size and height and ability, confidence on the stairs to go up between the 2 floors, please. And of course, an appraisal might be made about whether they're tall enough and confident enough on the stairs to go up and down. But when they're 17, there comes a point where you can say, well, I'm going to have regard to their age and size and ability on the stairs, but there comes a point where one can sensibly say that that test is obviously satisfied. So we don't accept the criticism that we're saying you disregard the terms of the statute. We say, actually, when you apply the terms of the statute, there must come a point when a benefit of this particular type is plainly outstanding. And the irony of the case, in a sense, is that the early cases said the courts will recognise a benefit of this type when they see them. And when we went before Sir Robin Jacob, as Lord Kitchen will remember, he said to my learned friend, Mr. Alexander, what, 23 million with no risk, not outstanding? My learned friend, I think, said, I heard that. And I think Sir Robin Jacob said, well, you were supposed to. So, there was one of the most experienced patent judges in the country recognising it when he saw it. And that was previously said to be the test. There's considerable public interest in it because it's such a large amount of money for a company to derive from a bare patent. And we respectfully say that actually the evidence that the hearing officer considered, which he did consider, how outstanding it was in amongst patents generally, the evidence from Mr. Emmanuel, whose evidence he preferred, was that it was extraordinary. And that is wrong to leave that out of account, just because the Unilever group as a whole is very big. The one issue which is not perfectly resolved is the extent to which the employer's duties are relevant. And the hearing officer, to be fair to the hearing officer, there was something of a delay. He was initially extremely keen to resolve the matter very quickly, and I had to produce my written submissions under some difficult conditions to facilitate that. But in the event, his decision came over a year after the final submissions had been concluded. And that may have resulted in making some findings which were not literally wrong, and we don't attack them in any way, but it might be said that they didn't actually make very hard-edged findings of a precise nature about some matters. In some respects, we say they were quite generous to Unilever, but we're content with the findings that he made. I think subject to one slight point, which is that his focus on the relevant contractual duties and how Professor Shanks was warned about what he should do in his early remit, perhaps wasn't as precisely resolved as it could have been. In short, he finds, could I just take the court to the relevant passage? It starts at E382. That's in Bundle 2, tab 19 in the hearing officer's decision at internal page 9. So, Professor Shanks, who the hearing officer found to be a very honest witness, and in fact the hearing officer refers to a slightly embarrassing point where there was a question about a colour photograph, and the entire legal team were pretty confident it had been black and white. And we're trying to be fair and say, well, I think Professor Shanks might have got that wrong. Actually turned out Professor Shanks was right and all of us were wrong. And so the hearing officer made very favourable findings about Professor Shanks's credibility as a witness. And he gave very clear evidence that although his contract of employment did not specify what he was to do, only a couple of days in to his employment, he had been given very strict instructions not to stray from his remit in relation to researching process sensor devices to assist in the control or improvement of Unilever's manufacturing processes. And that's at paragraph 45 on E382. And he gave evidence. He was a bit shocked about that because he had understood his research was going to be a bit wider and less restricted. And the hearing officer actually goes through this in some detail. And he deals with Unilever's corporate culture, which was the subject of some cross-examination, in paragraphs 48 down to 56. And that is pretty clear and was extremely striking before the hearing officer, which is perhaps why he recites it at such length. In particular, he says in line 2 of paragraph 48 on E383, he says, in particular, questions arise as to the extent to which Unilever's scientists were encouraged or discouraged from departing from their narrow remit. Mr. Samuel gave some useful evidence on this point. He said that working in the new product areas created a lot of distraction and disruption from supporting the main core business of Unilever and was discouraged. He gave an example of where Unilever had deliberately taken action to stop this sort of thing being disruptive to the business. It moved a lot of entrepreneurial activity in something called Unilever Ventures, which is run as a separate organisation where people who want to invest their own time and money in new businesses can do so without it being a disruption to the existing business. That was entirely consistent with what Professor Shanks was complaining about. When asked about the position of an employee inventor in Unilever, Mr. Samuel commented they were not paid to be an entrepreneur and agreed that if they were entrepreneurial, it was something outside of what they were being paid for, and accepted that the organisation is not set up to run with entrepreneurs taking independent decisions. And then paragraph 50, this reflects Mr. Samuel's evidence generally. He paints a picture where Unilever scientists should do the job they're paid to do in developing existing products and should not ever use their initiative to do something even slightly different, even if this is in addition to their normal duties. And that was very much pretty forceful and quite striking evidence, which gives context, we respectfully say, to whether or not it's outstanding for an employee, contrary to the warning he's given when he first arrives, to do precisely that. Unilever get 24.3 million for it and then go, yeah, but that's actually not outstanding. And then over the page at 51 to 56, there was discussion of some contemporaneous, well-researched articles by academics who'd had access to all the Unilever archives and been able to go through all Unilever's internal records to discuss that. And that, as we see at 55, none of the witnesses taken to the article disagreed with its findings. All the impediments to that sort of entrepreneurial or innovative activity. And 56, this article and evidence of Mr. Samuel provides support for Professor Shanks' evidence that he was strongly discouraged from pursuing inventions in areas not relevant to Unilever's core business, despite the isolated success of Unipath. And then here's the bit that we say respectfully is not literally wrong, but it doesn't quite deal with the point which we say it should deal with. And paragraph 57, he says, taking into account all the evidence I've heard on this question, so that means immune from scrutiny by an appellate court, I readily see how Professor Shanks formed the view that he was warned not to stray away from his remit of sensors for process control. I think, however, that Unilever was somewhat more open to his moving slightly beyond that remit than he asserted. It's clear that he was a respected scientist who was taken seriously, was given the freedom to set up an entire new section, the biosensors section, which is funded partly by CREF and partly by the Medical Products Group. On balance, I conclude Professor Shanks was made to understand he should not stray too far from his brief of biosensors for process control and process engineering, although he was given a wide remit within this brief. I, however, believe that he did have at least some freedom to develop his ideas in other areas, even if the level of interest for these within Unilever was in question, point to come back to below. So the small objection, if we may respectfully make one to that, is that the time when he makes the invention is the first 6 months. That's when he takes the risk of going outside his remit. And it's absolutely true that a few years down the line, Unilever sort of got interested in biosensors, including for process control. That's absolutely right, and he did have more freedom later. But we respectfully say it's pretty obvious that the hearing officer was really saying, I accept what he was told when he started, but later on he had a bit more freedom. And but even on the hearing officer's findings, which we say are adequate in any event, it's clear that Professor Shanks made the invention that he did at home, in addition to his normal duties, rather against the headwind of the culture of the Unilever group of companies within which he worked, and CRL in particular.
There's no challenge to the fact that Unilever owned the invention.
There's no challenge to the fact that CRL owned the
Beg your pardon, CRL owned the invention.
My Lord, yeah.
So what relevance does whether he made this invention at home or in the research facility have to the question we have to decide?
So, my Lord, this is a question. It's not decided, but there's a question of whether or not the way in which the invention is made is a relevant fact, by no means determinative, to whether or not it's outstanding. And we respectfully say, as a matter of common sense, it is relevant, because you've got the hearing officer approach, which it doesn't matter whether it's 1,000 people or one who generate £1 million. We say obviously wrong.
Well, I understand your submission on that point.
Yes, but because it's partly because what was said in all the previous cases is it depends on what the employer might reasonably expect from the employee's duties. That was a factor in the earlier cases. Now, it's one that Mr. Justice Floyd says is not a threshold requirement, that they've gone beyond their duties to get an award. So, but that's the opposite end of the scale from saying it's totally can never be irrelevant. It can never be relevant. So we respectfully say, as a matter, Parliament gave set a test of a word that can be commonly understood, namely outstanding. Now, the finesses of how it might be applied might be difficult, but Parliament did not say, for example, disregarding an incredible way in which the invention was made at absolutely no cost and no risk to the employer, completely.
Yes, well, those are different points, and I understand your submissions on
Indeed.
those.
But my Lord, all I'm saying is that if one's saying, I mean, they're all adjacent points, we say. They can't really rationally be passed, because you can't really look at no risk to the employer without saying, well, hold on a second, weren't they paying Professor Shanks to do precisely that? True for Dr. Kelly and Dr. Chu. £100,000 a year for Dr. Kelly, £80,000 for Dr. Chu. Not so for Professor Shanks, because Unilever got everything expected from Professor Shanks in his ordinary duties anyway. There's absolutely no suggestion to the contrary ever. So the question is, when you get a windfall that you're not expecting, and everything you've contracted for, is that more outstanding? We say as a matter of common sense it must be. Well, it's not a clever point, but we respect to say a common sense one. So that was one aspect of the context in which it was made. And my Lord, of course, I should just say, obviously, these have an obvious relevance to fair share, but we don't say those categories of facts are hermetically sealed between the two. That was one aspect of it. Then there was a disagreement with Mr. Stancliffe in Unilever's patent department about whether glucose should be measured or should be mentioned in the priority application. And this is dealt with at 386 onwards. Internal page 13, the priority application starts there, and you can see at the top of 387, just so the court has in mind, the scale of the challenge mounted by Unilever below included Unilever even disputing whether Professor Shanks actually invented any of the features that were referred to, on which Professor Shanks won. And there was a disagreement with Mr. Stancliffe about inclusion of references to glucose, for example, in relation in the priority application. And if we go to 389, the court will see the heading Tensions between Professor Shanks and Unilever Patent Department. So the delay was in part, in para 77, 4 lines down, the delay was in part due to a disagreement between Professor Shanks and Terry Stancliffe as to what should be included in the application. And eventually, paragraph 79, there was a degree of compromise and resignation in accepting that there was nothing that required immediate action, as referred to, no omissions that required immediate action in para 78. But the hearing officer then refers at 80 to the corroboration of the alleged disagreement between Professor Shanks and Terry Stancliffe in the half-year review, in which Dr. Kyle was involved. And at the top of page 390, Mr. Stancliffe explained that concepts could not be patented, but construction instructions had to be included to obtain a good patent with wide and sustainable patent claims. A premature application might reduce basis of future claims. Dr. Kyle suggested that traditional Unilever patenting approach might not be applicable in this rapidly developing area, and that Dr. Shanks and Mr. Stancliffe should try to reach an appropriate compromise. And he then deals with that, and at paragraph 85 on 391, 3 lines down, I'm satisfied that Professor Shanks wanted more detail and a reference to blood glucose testing in the application. Mr. Stancliffe took the view that there should be, these should not be included at this stage, but could be added in a subsequently filed application. I mentioned that in passing for two reasons. One is respondent's written case points out that there was no reference to blood glucose testing. It was just a device generally in the priority application. And this helps the court to understand the background to that. But two, we respectfully say all of the benefit that Unilever received was actually against a bit of a headwind in a number of respects. Firstly, because of he had to risk going outside of remit that he'd been told strictly to adhere to. Secondly, because there were some difficulties with getting the aspect which he envisaged being used commercially included in the priority application. And thirdly, because as the hearing officer acknowledges, Unilever did not have expertise in out-licensing or the skills dedicated team, licensing team that you might expect from a large company such as Unilever. So that does create the context for appraising whether or not the benefit derived was outstanding, we respectfully say. But my Lord, I appreciate, my Lord Kitchen, there's room for a number of views as to what is and is not relevant on outstanding. Our submission is you take a common sense view, you look at the facts as they actually are, rather than artificially passing them. But so that's the context, and that we respectfully say sets also the context for the assessment of fair share. And I hope I might be able to say fair share slightly more speedily. Can I just give the court the overview of the position on fair share, which is that the hearing officer fixed fair share at 5%, having rejected the analogy with Kelly at paragraph 193 and 202, which I'll take the court to in a moment, where Mr. Justice Floyd said he could conceive of circumstances where an endeavour effectively in a commercial context was more akin to an academic generation of a benefit of this sort, where 33% or more might be appropriate. So the hearing officer rejected the relevance of that and set the fair share at 5%. Then we respectfully say, unusually, Mr. Justice Arnold reduced the share to 3% on a basis which we respectfully say was both surprising because of his allergy to interfering in multifactorial decisions when they would help Professor Shanks, and because it was actually completely flawed. The reason for reducing it to 3% was to get some parity with Kelly, which is a completely different case, and because it was said by Mr. Justice Arnold that the hearing officer had not taken into account sufficiently the leverage of Unilever in extracting, as he called it, I think, the patents. Now, what we respectfully say happened there is that Mr. Justice Arnold acceded to the charm and elegance of learned friend submissions without a careful focus on whether it was really for him to ascertain the weight in something that was genuinely multifactorial. Fair share isn't like outstanding benefit. You haven't got, in outstanding benefit, you've got all the factors on one side, and then this generality of Unilever's overall global profits as the decisive factor the other way, which essentially we say, in some respects, unifactorial. In the fair share, there were lots of factors to be taken account of. And so in defence of that aspect of the hearing officer's decision, it was a genuinely multifactorial assessment, subject to the point that we took, and I appreciate, we were both appealing the percentage, and I have to face that, but we respectfully say that our challenge was really more one of principle, saying, well, it's actually wrong to disregard the distinction between what Mr. Justice Floyd had in mind in Kelly at 193 and a case where an employee is employed to work on the particular thing that they then invent.
Justice Arnold said that the hearing officer actually overlooked it, I think.
Yes.
Point about the financial muscle.
Well, he clearly didn't. Because
Just remind me, please, of the particular paragraphs in the hearing officer's decision where he did take it into account.
Well, what he had regard... Well, my Lord, can I preface... I will do that, absolutely. Can I preface it by saying this, that Unilever didn't get the finding on their contribution having been absolutely gigantic and essential because of the evidence before the hearing officer. So it's wrong to proceed on the footing that there was evidence that the reason everyone came and paid what they did was because of Unilever's financial muscle. It is right to say that the hearing officer identified the leverage, and it's one of the paragraphs we actually just looked at.
Yes.
The greater leverage. It's, I think it's 207 at E416. So he firmly had in mind the general background point that the different undertakings will have different leverage at 207 on page E416. And he's qualifying it's the tiny, £50,000 won't be outstanding for Unilever because of their leverage, they'll be able to get more than £50,000. So he absolutely had the point firmly in mind. Just Unilever's case on that did not go well. We had, for example, and this is slightly glossed over in the response written case, but the example of the Italian company that expressed interest in the patents to Professor Turner at Cranfield, and were interested in them and wanted to invest in something. And it took 4.5 months for Professor Turner to get a response from Unilever's patent department. Similarly, with Company A, as we've called it in the confidential network, the confidential list, Company A, there was a series of feverish negotiations with people flying from far afield, lots of meetings, heads of terms agreed, sent, please can we have a license from you? No answer. It was actually on a royalty basis, would have been worth many tens of millions, if not more. No answer. Chaser, chaser, chaser. Long delay. Eventually, a letter after a minor delay by Company A saying, well, of course, as the delay's been mutual, which, given the party they were dealing with, might have been thought to be rather rude, and they eventually say, well, we're going to look at this again. And ultimately, they take up a paid license, fully paid up license. So there was lots of focus on the extent to which such leverage as you might expect Unilever to have had actually been functionally deployed to good effect. And the fact that the hearing officer makes the findings that he does about Unilever's licensing expertise not really being what one could possibly expect from a dedicated skilled licensing team, informs the fact that Unilever did not get the finding that it was all because of their leverage that they wanted.
No, I've got in mind paragraphs 139 to 143 of the hearing officer's decision, where he appears to draw his conclusions together on the licensing efforts. And I can't at the moment see, but perhaps you could point out to me if I've missed it, anything saying that Unilever's leverage played a material part in securing the licensing rates that they in fact secured.
Your Lordship's right, he didn't find that it did. And the reason, the context of that is not, we respectfully say, not surprising, because what actually happened was Unilever was approached by someone offering, saying, please can we take a license? So everyone approached Unilever to offer paid-up licenses. Now, Mr. Emmanuel, in his evidence, said, well, one of the odd things that you tend to notice if you're a licensing expert is that if everyone's beating a path to your door saying, can we pay you a fixed amount for this with no royalty, that's a clear indication that they value what they're taking far higher than you do on your fixed amount. That's what everybody's asking for. And the hearing officer, the generosity of the hearing officer's findings about Unilever's patent activities can actually be tested. I can give the court a reference if it's necessary, but the hearing officer says that Mr. Emmanuel said their efforts were generally good.
But then he qualified it rather dramatically.
Well, your Lordship's right, but not only did he qualify it in oral evidence, but when you look at what Mr. Emmanuel's report actually said, I mean, he's extremely charming and measured. He said, generally good, subject to the points that I would make, which included not doing any of the things you'd normally do first to work out what the market was and how you have any sort of strategy, navigating without a map or compass, and not really knowing what they were doing. So he was very gracious, but it's a little bit surprising. I mean, I'm not challenging the finding. It's just right that the court should be able to look at the page if you want to and see that generally good was, it wasn't just in his oral evidence that he qualified it, should we put it that way. So your Lordship's right that it didn't appear to be the case. I mean, Learned Friend was very keen on the point as an assertion, but there wasn't actually any evidence to support the assertion to reach the level of a finding. And we respectfully said all the evidence rather pointed the other way. But what can be said of the hearing officer is he had well in mind the fact that that could be the case, because he expressly recited 207. So in our submission, it's not right to tune down from Unilever keeping 95% of the benefit, to Unilever keeping 97% of the benefit, the hearing officer's decision, on a basis for which, for good reason, the hearing officer didn't find in Unilever's favour.
You're submitting we should adjust the award of 5% upwards rather than down.
My Lord, that's completely fair. And the reason we say that is not on the basis of giving more or less weight to leverage or any of the other individual factors. The reason we say that is looking at Mr. Justice Floyd's decision in Kelly, which I can take the court to.
Yes, but you say in relation to the hearing officer, there wasn't an error of principle on his part which entitled Mr. Justice Arnold to alter the figure.
No.
But do you have an error of principle to alter it upwards?
Well, my Lord, that's precisely the difficulty I face. but I mean, hopefully it's a fair submission to point to the difference of a litany of minute factors in a basket, of which Mr. Justice Arnold then picks upon one and makes a rather surprising adjustment, supposedly to make it more like Kelly, when that's exactly what the hearing officer compared as precisely the basis of the hearing officer's decision. He precisely considered whether it was similar to how it compared to Kelly and reached 5%. And then to make it more like the outcome of Kelly on wildly different facts, he takes it down to 3%. Both of those approaches, one I accept is of principle. The parallel with Kelly could be said to be one of principle, or approach at least. But the other is plainly, minutely fine-tuning on a flawed basis, one of a number of factors. And I hope it's a fair submission to make in our favour that the consideration we're inviting the court to give to the level of the award is really one of approach. And that is to say, what was the hearing officer right, really to disregard what Mr. Justice Floyd, who after all was a binding decision on the hearing officer at the time, had said in Kelly, and I keep mentioning Kelly, so I probably ought to take the court.
It's about time we looked at it.
I think we ought to get there eventually. So Kelly is in volume 11B, tab 12, and that is at begins at E3148. And can I just take the court forward, just to the head note briefly? If we look at, on page 3154 at H47, generally, employees' share of the value of a patent might in principle lie somewhere in the broad range from nil to as much as 33% or beyond. In the present case, the employees' share lay towards the bottom of the scale, having regard to the factors under consideration. A very conservative figure had been taken for the valuation of the benefit. Taking the same approach, the share of the benefit, 3% of the value of the benefit, represented a just and fair award to the employee claimants. And then if we go back forward to 3184, we've got the two paragraphs which the court's concerned with essentially, paragraph 193 and paragraph 202, 193 refers to evidence about a fair share for the Biological and Biotechnology Sciences Research Council, which the court will see in the bottom half of paragraph 191. And 192, by the time he came to make a second report, that council raised its rates to 33.3%. This was done in order to bring its rate into line with universities, which typically pay their academic inventors a third of the exploitation income. Not surprisingly, he wished to disassociate himself from this comparable figure. Then 193, I do not think the position of academic inventors is comparable with the position of the inventors in the present case. I suppose if an inventor in industry made an invention which created an entirely new product and income stream for his employer without any substantial input from the employer, a share in this region or even higher might be justifiable. But that would be a very different case. And he essentially repeats pretty much the same thing at 202, which is the paragraph to which that part of the head note refers. Now, just pausing there and just unpacking that paragraph a little more, the second line is where it starts. I suppose that if an inventor in industry, well, that's Professor Shanks, made an invention, which he did, which created an entirely new product and income stream for his employer. Well, pausing there, he didn't actually create a new product in that sense because it didn't get that far, but it was exploited by licensing the bare patents. But he created a completely new income stream, totally unexpected, outside all of the areas in which Unilever operated, or the products which it operated, without any substantial input from the employer. I mean, it's precisely what he did. A share in this region or even higher might be justifiable. And there was gallons of evidence before the hearing officer, reasonably reliably, including from Mr. Emmanuel, who was preferred on the licensing matters, about sort of percentage shares. And I just show the court, only by way of background, very briefly, the reference to the Nottingham University study, which is at E1595, which is in bundle 6, tab 47. There was a study carried out by Nottingham University, so neither party in the proceedings, 61 institutions with agreed policies on how income's distributed between the inventor, the inventor's department, and the institution. Policies for the mean distribution of net license income in excess of 100,000 was 38% for the inventor on average, 27.1% for the department, and the institution got 34.4%. And 19 institutions offered 30 to 35%, 20 offered 50%, none offered inventors less than 15 or more than 50%. And so that's the sort of uncontroversial background evidence about those institutions to which Mr. Justice Floyd was referring. Now, none offered less than 15%. We've respectfully invited the court to consider an appropriate bracket of an award to be between 10 and 20%. So the bracket, the middle of that bracket, is the level below which none of the academic institutions offered an award. So, my Lord, I take the point that we too were appealing that decision. The question really is, obviously this court isn't bound by what Mr. Justice Floyd said, but in a sense...
Well, it was an I suppose, speculating about a completely different set of facts and suggesting something.
My lady, that's true.
You're treating it as if it's an act of parliament.
well, my lady, that's overstating it, obviously. But the short point is this, that there is interplay between academic institutions and industry at levels now which were unprecedented when the Act came into force. And it's not irrelevant to have regard to that. And Mr. Justice Floyd wasn't sort of speculating in that sense in a vacuum. He was considering how these provisions might work.
Well, what are the factors that would make a fair share for an inventor working in industry so much less than a fair share for an academic working in a university or in a research council?
I was wondering the very same question, and one of the factors might be the salary scale.
Well, that had crossed my mind too, or possibly a bonus scheme or something like that. But what are the factors?
Well, those are the sorts of factors that...
Yeah, academics are not paid very much. I do know that.
My lady, yes. And in fact, that was, of course, the case with Professor Shanks. He wasn't paid very much either. So that was partly why we saw it, because Colworth had characteristics of a sort of research organisation in the way that people were employed as scientists. And he was, of course, he was recruited from the RSRE as a suitable research scientist. So, one of the interesting things, one of Unilever's witnesses candidly admitted that he'd, at the management level, frequently had bonuses in excess of Professor Shanks' entire salary. But what he did say was that Unilever just was not set up to recognise in any way this sort of effort. And that slightly brings us on to the extent to which Unilever's ability to recognise this type of benefit which it derives from outside its main product lines fits in with my learned friend's assertion in the respondent's written case that these proceedings are working well. He says this case shows that these statutory proceedings are working well and don't need to be revisited.
Do you have nothing more to say in answer to the questions that my lady and Lord Hodge asked a moment ago?
About the justification?
Yes. I mean, if you have somebody working in industry who isn't paid much more, if any more, than he would be earning in a university, and he produces an invention, and if there's a going rate in universities...
There's no reason why he shouldn't be paid.
Well, why not?
Well, precisely, my Lord, I'm sorry, that's precisely our case.
Well, it's not, because you're only asking for 10 to 20%.
Well, my Lord,
why are you being so modest in your...
Well, I'm embarrassed by my own modesty, my Lord. I mean, we tried to not overclaim in any sense, try and reach a reasonable figure insofar as we could. And the bottom of the scale on the Nottingham study was 15%. And it seemed that an award, a bracket of award which captured that bottom figure was, on any view, not an unreasonable one to ask for.
Isn't it fair to say that the hearing officer did look at other aspects of the context in, for example, paragraphs 239 and 240? Because he had evidence before him from Mr. Osborne about what rewards people in R&D-based industries such as Unilever might generally expect.
My Lord, he did.
And a contrast between research-based industries like Unilever and universities.
Indeed. And there are 2 points to make on that, my Lord, if I may. One is the observations he made about Mr. Osborne's evidence at the beginning, set the context, because he wasn't able sometimes to understand the justification for what Mr. Osborne was saying. And he said that Mr. Emmanuel's licensing expertise just shone out. And so he preferred the evidence of Mr. Emmanuel pretty clearly. But also the point is that Mr. Osborne's observations in that respect were really more a prisoner to the Kelly-type situation, the Dr. Kelly-type situation, where you're employed in industry by a huge company that says, don't worry, Mr. Green, we'll back you with a huge lab and you can pursue this at our expense, which you might not be able to get that funding if you're an academic. But that's where you're working on what they want you to work on. And our point was, it's not really fair to equate where you're paid a salary to work on something and you do invent something and you get an award, with the situation, which is much more akin to an academic invention in that respect, where in the course of your work, as a side issue, you invent something that's completely outside your strict remit at the time you invent it. And you're straying from what you've been told to focus on. And it's in addition to all the things you've been paid for. So I suppose in answer to my Lord's question earlier about why we're being so modest, maybe a mistake. But
Well, I'm wondering if, and I'm just asking a question. I have no idea what the answer is. Whether we're comparing like with like entirely. I mean, is the income that we're comparing, that you're taking a fraction of, is that strictly comparable? In the university setting, I suppose the academic will make an invention. But its commercial exploitation will presumably be for others.
So they'll only get the
possibly
license.
a related. I mean, universities these days will probably have a related company which does that. But,
Sometimes, yes.
But the third that he's getting will be a third of the revenue obtained from, or the capital obtained from simply the patent itself before commercial exploitation.
yes, so, my Lord, that's right. So that's
in an industry, if you're getting these percentages that are discussed in Dr. Osborne's evidence, are those percentages of the same figure, or are they relating to, I don't know, what might be the income from actually commercially exploiting it in terms of selling or producing and selling products?
My Lord, your Lordship's right with one qualification. I think not the income, but the profit.
Right.
I think referable to the profit.
Yes.
So it might be much bigger.
Yeah.
So that has an effect on the respective
I see. So
percentage.
you're not actually comparing.
You're not comparing like with like, which may explain a difference in percentages generally.
And in this case, because there was no product made by Unilever that was exploiting the invention, we're actually more akin to the academic than we are to Dr. Osborne's
Yes.
range of industry figures.
Yes.
Is that right?
My Lord, yes. The sum that we're concerned with is more like what the academic institution has to share out,
Yeah.
and the context in which he actually invented it is more like it. So it's those two reasons why we respectfully say that there are points of principle about how you approach it, which are not to do with sort of minute fine-tuning of one of the factors of effort and skill.
May I ask, what was Dr. Osborne's basis for the 2.5 to 10%? Was it based on profit or turnover or what?
I'm not sure that was always clear. If your Lordship turns to the beginning of the hearing officer's decision where he deals with the relevant parties' witnesses, it's at E376. So, paragraph 7 is Mr. Emmanuel. Where he says Mr. Emmanuel has had long experience of licensing and technology transfer. He gave expert evidence across the topics of the case. His licensing knowledge and experience was apparent. And there's also another reference. We can look at paragraph 12, where he contrasts Dr. Osborne with Mr. Emmanuel.
Yeah.
And he says, Dr. Osborne is CEO of IP Pragmatics, an IP asset management company. His expert evidence covered the full range of topics. On licensing issues, he came across as less confident and experienced than Mr. Emmanuel, and some of his expert opinions were at times unclear as to the precise justification behind them. And there's also a bit where I think it's Mr. Emmanuel whose expertise shone out elsewhere in the decision. So, my Lord, one can fairly say that overall, broadly, Mr. Emmanuel was preferred.
Yes, but Dr. Osborne's evidence at paragraph 240 about public sector research institutions, which presumably didn't profit by producing the things, but would have sold on the know-how, and the other sources of information, they didn't depend on Dr. Osborne's personal experience in licensing, did they?
My Lord, no, that's true. But the question of what sums they are being applied to and those matters of detail aren't dealt with there. I mean, the German scheme, of course, is completely different because you get an award on every patent, even though it's small. And at different stages, the award goes up. So we got a completely different situation. We got a completely different thing here, where you only get one if it's outstanding, and then you get a fair share. So, but it's. I mean, Mr. Emmanuel's evidence laid it all out pretty comprehensively, with reference to fairly neutral and clear study. I mean, the Nottingham University study, they weren't going from one party or the other.
Yeah, but did he also, as well as having the Nottingham study and to which you referred, did he also have any explanation of industrial rates and whether the percentages were percentages of profit?
He found it quite difficult to get details from individual companies about their own schemes.
So that's perhaps why, in the case of Dr. Osborne's evidence, he looked for public sector research institutions which probably published these matters.
Well, the public sector institutions were all included in the Nottingham study. That's the important point about what I perhaps didn't highlight it enough, but
Sorry.
because it was
61 institutions.
Yeah, indeed. And some
UK
of them,
institutions.
some of them were academic, some of them were research institutions.
Yeah.
So you had a blend, and that's why. But the real point of principle is, what sort of situation is this one?
You seem to be setting up a sort of two-category system, academic or quasi-academic on the one side and commercial on enterprise on the other side, for working out what's a fair share.
Well, my lady, I'm not sure I would say they're hermetically sealed categories, because I think that's not right.
But for it to be an error of principle, you've got to have some sort of categories. That's the error you're relying on at the moment.
Yes, I think I would probably say it's a matter of characterisation rather than categorisation, the error of principle, because if you don't recognise that Professor Shanks has the characteristics which would put you more in the category of the academic inventor than in the starting at the Kelly end of the spectrum, then you've made an error of principle. It can be, I do agree, it can be categorised by a bright line distinction because there are clear distinctions of principle to be made. If what you invent and is patented and the benefit is derived is invented with the full support of your employer and it's what you're paid to do, and you've had a salary of £100,000 for the years while you've been doing it, that's very different. It's a matter of principle. It's a different category of situation from one where you do everything you're employed to do for your employer, and there's this additional thing beyond your contractual duties.
But it's sort of artificial because you're directed to have regard to all the circumstances.
My lady, yes, and we say those are important circumstances, not that shouldn't be disregarded. But that was actually my submission below, is that it doesn't say only look at those categories in section 41.4. Actually says all the circumstances. And you've got to say, well, this is obviously a completely different situation where there's no invention cost. It's effectively in addition to everything he was doing otherwise. It's much more like an academic inventor. And particularly having regard also to the fact that he had a relatively modest salary and a Volvo. It's not the swanky CEO being driven around in his enormous Mercedes and the huge salary, and nor is it somewhere in between. So, I mean, my lady, I hope I answered that fairly. I mean, you do have to have regard to all the circumstances, but one can pretty clearly recognise different situations. We respectfully say.
In a nutshell, how would you define the error of principle that you say the hearing officer has made?
Well, the error of principle the hearing officer made was simply saying he doesn't agree this is anything like what Mr. Justice Floyd had in mind in Kelly at 193. That's the error of principle we say he made, because actually, when you look at the facts, it's right to look carefully at what sort of situation it is before you do the exercise of working out within that context what the right figure is. And there's no point in all these hearings hearing evidence about the overall picture of inventor awards generally, if they're not going to be at least informed to some extent what sort of award should be made in a very, very similar situation. We respectfully say that's a requirement of rationality.
Are you not also saying that the hearing officer was wrong in paragraph 244 to say that Professor Shanks was in a very different situation from an academic?
Well, we are saying he's wrong in 244 for a number of reasons, actually, my lady. Your ladyship's right. I mean, if you look at the third line of 244, he says, I do not accept Mr. Green's assertion that this is a case of an employee creating an entirely new product and income stream for the employer without any substantial input from the employer, as Floyd J was contemplating. Well, the only word he's right about is product, in the sense that they got the bare license fees and didn't develop the product themselves. But we respectfully say the substance of that finding is wrong as a matter of principle and logic. And this is exactly what he was contemplating in Kelly. Now, where you go from there, obviously requires to be followed through, but he is wrong, we respectfully say. And it says that it seems to me that the employee had done far more than Professor Shanks did in developing the product. I mean, that's not the right test, because if Professor Shanks had worked on it and been involved in getting many billions of pounds through its manufacture, and he'd been paid a salary for many, many years, he would have done a lot more. But we respectfully say that wouldn't actually play into the analysis as the hearing officer seems to say it does.
Just give me the reference to the Chartered Institute article to which the hearing officer refers.
My lord, I confess I can't, but we can find it and give it to your lordship.
Well, in 7 minutes' time, you will have
I'll have
every
a moment
opportunity of tracing the reference. Yes.
I'm most grateful. So in answer to your ladyship's question, 244, we respectfully say is an error. He just got it wrong.
But he's wrong in several respects, you say.
We do, in that way.
are you doing, Mr. Green? You seem to
I hope
be
I'm doing rather
making quite
well.
good progress.
I hope I'm doing rather well. I mean, my lady,
Oh, no, I don't mean that.
I mean speed-wise. I'm
I
not
don't
talking
mean in
about
terms of whether you're
merits
convincing
wise.
us.
Might be a
That's
different
different.
picture. But,
It was in terms of time.
yeah, well, that was what I was answering.
Yeah.
I hope that was clear. Lady, what would, if the court were prepared to rise now, I think I would be able to work out the extent to which I really need to dwell on any other points more speedily and take up less time after the short adjournment, if that were convenient. But I'll definitely be done before my 2:30 time.
Entirely up to you, Mr. Green.
I'm
You
most
can use the time available to you in whatever way you see fit,
I'm most grateful.
within reason, of course.
Most grateful.
We look forward to hearing from you at 2:00. Court will now adjourn.